All right, we are live on YouTube and you may begin whenever you're ready.
All right. Welcome to tonight's full design review board meeting. I call us to order. Tonight's February 20th, 2024. We have a quorum of 1, 2, 3, 4, 5 staff. Is that right? And including myself, 6?
Correct, 6.
Okay. 6 out of our 8 members. I am looking for a motion to approve tonight's agenda.
So move.
There's a motion and a second, or does anyone second that?
Second.
I hear a second from Brian. All those in favor say aye.
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 All right, motion passes. For
Aye.
that. Approval of last meeting minutes, staff. Do we have some we need to approve?
Yes, we have January 16th, January 23rd, January 30th, February 6th, and February 13th meeting minutes to approve.
All right. Do I hear a motion to approve January 16th, January 23rd, January 30th, February 6th, and February 13th meeting minutes?
So moved.
So moved.
There's a motion. Do I hear a second?
Second.
All right. All those in favor say aye.
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 All right. Motion passes. I'm now moving into general members' comments. So this would be about any application that's not on the agenda tonight. It's a general public meeting for Reston Association, so any general member comments are welcome. All right, I don't see anybody raising their hand, so we will jump into our agenda. So up first, we have an appeal for 2310 Millennium Lane. Is the appellant here? I believe he is because it's Cam.
Yes, we have the appellant here. I was unable to identify the applicant.
Okay. All right, Cam, state your case. What do we got?
Awesome.
Either new information or misapplied guideline?
I'm Cam Adams. I'm the Director of Covenants Administration for Reston Association, and I'm filing an appeal on behalf of the Reston Association Board of Directors. This application came in to a panel on January 9th for a front door replacement. The association is appealing the decision for misapplied cluster standard. The existing door color is not in conformance with the generation cluster standard, regardless of the location. The cluster has indicated there is no interest in updating the standard to permit the color that is existing. In addition, the current application does not provide the actual existing color. And we have been in communication with the property owner and their agent. I believe this property is pending a sale at the end of this month. They do and did have an approval for the door replacement. So Reston Association is only appealing the decision that the DRB made on January 9th relative to the door color. It is not and has not been a color that has been approved by the DRB as a color for the generation cluster color palette, nor has the color been provided as in terms of identifying the appropriate color that is existing. The cluster standard on page 41 of this application is very clear. There are actual color palettes that are associated in color schedules that are associated with this property. So all homes that have the Sherwin-Williams Link Gray siding are required to have the Sherwin-Williams Austere Gray as a trim color, and then the Sherwin-Williams Arresting Auburn as the front door color. I believe based on the DRB's decision in the previous review, the context of the approval was based on the door not being visible from the street. However, the DRB does need to consistently uphold the decisions of their previous DRB-approved cluster standards and color palettes. And regardless of the location of the front door, if there was interest for the cluster to allow such modifications for those homes that are having doors that are not visible from plain view or street view, the cluster should be encouraged to update the standard to reflect that. So the color is not in the color palette. And in fact, the color palette has been in place to some degree since the early 2000s. So based on the timeline of the original replacement of the front door, even at the time of replacement, the existing color is not and has not been in conformance with the cluster standards DRB approved palette. Thanks.
Just want to ask one question. So you're not deferring the door style, even though that's not part of the cluster standard from what I can tell either.
So the DRB actually in 2006 approved the door style. So that is not up for.
There just was no color in that. Because was there, do we have that official approval letter from 2006?
It's not in the application, no.
Okay. So, but we know, but I guess you guys know that there was not a color designated.
The decision letter actually quoted it saying that it needed to conform to the DRB cluster standard.
Oh, okay. All right. Okay. Thank you, Kim. John, do you have any questions for Cam?
No.
Jim? I do. Sorry, one question. Who was on the panel?
That's gonna be Sarah, Elena, and Emily.
All right. So Emily's the only one that's here that cannot vote on the appeal. So just take that into context, Emily. So John, sorry, did you have any questions?
No.
Jim, did you have any questions for Cam?
No.
Mike?
No, sir.
Brian?
No questions.
Emily, does what he's presenting sound accurate to what you guys reviewed?
It does sound accurate to what we reviewed. I believe in the context that while we reviewed this, the homeowner was trying to sell the home. She was widowed and was trying to get her home in compliance for sale. And with the front door painting, it was quite a considerable cost to get the door done correctly without replacing it, basically, and to paint it because it is a steel door. So that was the only note that we had, was we were hoping to act in the original applicant's favor to help her get the home on the market. But yes, everything else sounds correct.
Gotcha. Okay. Does anybody have any other questions, any thoughts? Want to make a motion?
I think it's pretty
I'll make-
straightforward, Michael. I would make a motion to, I guess, uphold the appeal, or what the heck is the phrasing there? Or
you would want to accept the appeal.
accept the appeal. There you go.
Yeah. So there's a motion to grant the appeal or accept the appeal.
Yeah.
Do I hear a second?
Second.
All right, there's a motion and a second. And just for clarification, I would say it's because there was a misapplied guideline, or in this state, a cluster standard, which is, pretty clear. So all those in favor of the motion to accept the appeal, say aye. Aye. Any against?
Aye.
And then Emily abstains. So motion passes 5-0 to 1. So we will hear the case de novo. And staff, we just have to hear the door color, correct?
That is correct. And just to let you know, the applicant has not been identified. So if they are here, could you please raise your hand? Otherwise, we'll be reviewing the application.
To me, it's not pertinent that they're here necessarily, because I'm just going to make a motion to deny the color submitted, and that they need to follow their cluster standard.
And then just keep in mind with the time frame.
Yeah, I mean, since it's part of a POA, I mean, there's there's a couple ways. Either the new homeowner is going to have to deal with it, or she'll have to take care of it. So I would say, let's just say 60 days.
So you have the motion, right?
So there's a motion to denial with a 60-day to go. I mean, to me, I'm just motioning her denial. I know it's an existing condition, but I mean, do we really need to put a timeline on it? Because technically, isn't this more a covenants than thing? Because it's a denied application.
It's a denial. Anytime we have an action to deny, that element would have to come into conformance. So you would need to put a timeline on when they should paint the door the correct color.
Okay. All right. Yeah, 60 days is fine then.
I'll second your motion, Michael.
All right. Any other further discussion? All right. All those in favor of the motion, say aye.
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 Aye. Any against? Any abstentions? All right, Emily's going to still abstain. So I think I have a 5 vote. Brian, did you vote? I just didn't hear you, I don't think.
I did. I voted for
You
the
did. Okay.
motion. Yes.
All right, so 5-0-1. Motion passes. All right. Jumping over to next application is 1631 Washington Plaza. This is also an appeal?
That is correct. It is an appeal. And this is an appeal from the affected party. So I'm going to unmute the affected party.
And just so for anybody who's on the line, just so we know the way the appeal process works is we hear from the appellant. If the appeal is granted by the DRB, then we will hear the case de novo, which basically means we'll hear it over. We will not hear from the applicant unless the appeal is granted. So I just want to make sure that everyone's clear on kind of the process, so nobody gets upset if nobody gets to talk. We only hear from the applicant if the appeal is granted once either misapplied guideline is proven or new information. So just kind of laying out that. So Mr. Barry, are you here?
I am. Can you hear me?
Yes.
Yes. I would like to have my counsel, John Coward, who is on this meeting. I would like him to speak on my behalf, if that's okay.
Yeah, that's fine.
Yes, this is John Coward here. Can you hear me, Mr. Wood?
Yes, we can, sir.
Okay. So I take it that you received my letter with Mr. Barry's appeal request because was flashed on the screen. So I take that as an acknowledgement that you received the letter and the attachment. How much time do I have, just so I don't run over? Or
I mean, technically, you have as much time as you want, but you know, don't put me to sleep.
Right,
So.
I understand. So, I think that this is a matter that the DRB, or I think several members of the DRB are already familiar with it, because I think, as I understand it, it's been before the DRB panels on a couple of occasions. I represent Mr. Barry, Mr. Alec Barry, who's the owner of Unit 1638 Chimney House Road in Lake Anna of Reston Condominium Unit Owners Association. And the applicant is, well, there's a tenant, Delia Italiano, but I think that the unit is owned by the Baslios family real estate company. If it's okay with everyone, I'll just refer to it as Baslios so that you kind of know what I'm talking about, if that isn't confusing for everyone. So as the DRB knows, that the 1631 is a commercial unit, and 1638 is a residential unit that is located above the commercial unit. The commercial unit, to my knowledge, has never been used or developed as a restaurant, and was not intended to be had to have a restaurant use according to the original designs of Lake Ann. So this is sort of a change from the overall pattern of design that was established by the developer and was confirmed by numerous uses over the years. I believe it was an antique store or a gift store or something before it was purchased by the applicants. And there's a very unusual design here where Mr. Berry's unit, the front facade of his house, like the front of his house, is on the back, and then the front of the commercial unit is down below facing the Washington Plaza. So the back of the commercial unit is the front of Mr. Berry's unit, which as the DRB is aware, this kind of presents some real challenges to redevelopment of it as a restaurant because of the needs to have certain ventilation requirements. So what we're here to do is to appeal or to request an appeal of this DRB's January 23rd, 2024 decision letter, where it approved an exhaust shaft screen, a rooftop screen, water heater discharge pipe, a gas line, an air intake louver, and HVAC refrigerant lines. And there's sort of a number of issues with this, and I'll try to summarize them the best I can. First of all, Mr. Berry and I have submitted a books and records request to Lake Ann of Reston that I've provided a copy of to Mr. Adams. I submitted that books and records request to try to find out more information about the drawings, the builder drawings of this unit, the architectural approvals that were made, some of the documents that were referenced in approval letters that the applicant had submitted to this board, and to find out about what the current status is of a large hole that was cut through a slab of concrete that was a structural reinforced concrete that also is a fire barrier. Try to figure out if kind of what's going on. I mean, it's those slabs in a condominium they perform a lot of functions, such as to support the structures above and to provide a fire barrier. If this is a restaurant, restaurants, I mean, God forbid there would be a grease fire or some other kind of fire that could come up through this hole. And as you can see in this picture, you can see in this photograph that's in front of you where the rebar was cut through. And to my knowledge, there's nothing that indicates that this structural and fire protection issue had been adequately addressed by LARCA or by the applicants. It's just something that was done, but wasn't really carefully thought out. Or it was adequately presented to this DRB in a way that it could be deliberated as something that's relevant to the application and to the appeal. This area that you see here is in this photograph is not a part of the commercial unit space, and it's not a part of Mr. Berry's unit. What we're looking at is the surface area is a limited common element that's designated on the condominium plats as for planting. So this is supposed to be a planter area. And this slab that you see here that was cut into, it's a general common element of the LARCA association. So this is property that is really LARCA's job to maintain and to come and to sort of represent LARCA with it before this board or the county or whatever, because it's them, not the commercial unit, who has the rights and responsibilities with respect to protecting this structural and fire protection feature. So the shaft that we've been talking about was constructed on top of this opening here, and we've requested that LARCA do an inspection of this unit and to allow Mr. Berry's engineer to also participate or to take photographs in that inspection. I haven't received any kind of response to my books and records request or other inquiries to LARCA's attorney. I don't want to sort of throw out any negative inferences that this board ought to make by the fact that they haven't responded, but I think that there are some facts here that are important that have not, I'm not yet in a position that I can adequately explain to the DRB because the books and records request has not been responded to. So I think it certainly is something where the appeal could be granted and then a deferral could be granted so that LARCA could provide more information that we and the DRB could use to kind of really understand what's going on with respect to this, and really ultimately who is the proper applicant for something like this. So this area, as I mentioned, this photograph doesn't really capture it, but if you could flip through to the next page, it might show. This is a picture of the shaft. You can see you all are familiar with pictures of the shaft. And then flip ahead to the next page. This is a section of the bylaws that explains that this area is a limited common element assigned to Mr. Berry's unit. Can you flip ahead a couple more pages? And you can see here is a picture of Unit 1638, and so you can see right in front of it that this area that we're talking about is set aside as a limited common element for planting purposes. And of course, as a limited common element, it's an area that is under the control of the Unit Owners Association, but Mr. Berry enjoys an exclusive easement for the use of that area. And it is one of the bases of our appeal that while the association does have the authority to make certain decisions about it, it can't sort of give that land over to another unit, because that would disturb the easement rights that Mr. Berry has to this area that is marked out here with the dotted lines. So there, under the Virginia Condominium Act, it's forbidden for a unit owner to do something that impairs the structural integrity of a building unless it's explicitly allowed by the condominium instruments. So that would include the slab. There's also a part of the Condominium Act that says that you can't change the exterior appearance of the condominium without, unless it's specifically permitted by the bylaws of the condominium. And if you look at the way that this was handled by LARCA, they haven't really presented the applicant with a way to kind of come before here to request Reston approval, because if you look at their approvals, like for example, if you look at this approval letter that they have submitted that's attached here, it says, this approval letter doesn't say, okay, Basilios Family Real Estate, you can go to Reston and you can kind of take it from here. We're handing off the baton. You guys can go up to Reston, and we're kind of like letting you manage this issue. That doesn't say that at all. What it says is that this has to be approved by the County Architectural Review Board, and it even uses the word exact plans and specifications. It also states that approval does not include the exterior shaft attached to the exterior wall, which is denied in part, as explained in the letter dated November 13, 2023. So there is a part in here where they've been denied by LARCA. This is a LARCA limited common element and general common element. LARCA said you can't do this. There's a mysterious November 13th letter that I've requested that would explain that ruling hasn't been provided, and Mr. Berry was not permitted to attend this meeting, this December meeting where this letter was issued. So there's all sorts of problems here for this board to sort of try to use this, because this letter doesn't really, this is not a power of attorney instrument or some kind of representation letter where they say, well, this is, we're kind of delegating it to you all to take it from here. This is not that. And in fact, this is a denial letter. So this, I think that this presents this committee with a very thorny set of issues that I think would warrant the appeal being granted. And I know that this has been going on for a long time. I know that this project has been going on since 2021, and that they'll be coming back here. And a lot of work has been put into this by the applicant to try to make this work. And I know that the DRB is trying to make a correct decision. I think that it's, I just don't think that this shaft project, and this is really moving Reston or Larka forward. And I think it's sort of holding, it's going to kind of hold things back with respect to this particular building. It's not really a kind of what I think is envisioned for the future in terms of redevelopment and upgrade of things. The rest indeed, as I'm sure this board is very well aware, that the attractiveness of things is definitely within the subject matter of that this board can consider. The harmonious relationship among structures. I think we've identified numerous issues that are raised here in terms of the harmonious parts of this building. And the impact of noise, I think Mr. Berry can further support this by explaining about how he recently heard a large amount of noise coming into his unit from this shaft, from some activities that were being conducted in the commercial unit. If the board would like to hear about that, I'm sure Mr. Berry would be willing to explain that further. But there is a serious noise issue here that doesn't seem to have been adequate, that doesn't seem to have really been kind of presented to the board in a way that it can kind of have take kind of deliberate the facts and then the kind of rules and laws that are applicable. I know that the board entered a decision that treats this shaft unit and the ventilation system as a temporary structure that's supposed to be removed at the end of whenever it's no longer being used. But I think that it's sort of, from experience, one knows that if something's been improved so that it can be used for as a restaurant, that whoever wants to rent out or buy this unit in the future is probably going to be very interested in having a commercial kitchen capability because of the value that it adds. And so I think that that while there is that language in there, and while I think that potentially could help Mr. Berry at some point, it seems I don't think that it provides the amount of protection that is needed here, because there really is no sunset provision that would kick in if, let's say, there was a change of tenant or a change of owner. That issue I don't think is been adequately addressed in this order. And so what we're asking today is for this appeal to be granted and for this approval that was given in January to be rescinded.
Great, thank you. Can I ask you a question about the December 15th letter that you guys presented? So that was going to be my main question is, so you've asked for this November 13th letter and you've been unable to get it? Because that was going to be my question, because I don't have access to it either. Yes, I emailed Mr. Champ and Mr. Adams a copy of this books and records request letter
that I submitted to Whiteford, Taylor, and Preston, and item number 4 is specifically this November 13th letter referenced in the December 15th, 2023 approval. So I realize that Reston does not sort of manage the internal business of LARCA in terms of its governance and its way it conducts its meetings and everything like that. But I think that given the sort of very unique issues that are presented by this application, that I think that resolving this books and records request would allow for the DRB to make a more informed decision in terms of what's being presented to it.
Okay, thank you. Let me see if anyone else has any questions for you, and then we'll have some discussion. Okay. John, did you have any questions for the appellant?
Not right now.
Jim, did you have any questions for the appellant?
No.
Mike B,
I do not have any questions right now.
Brian,
No questions.
Emily.
None for me.
So my only question is for staff. Have we, because we did not have this December 15th letter as part of our review last month. That's accurate, staff?
That the November 13th.
No. The letter I'm looking at right now, this December 15th letter, because the only letter we had before was about line sets and about how the line sets were approved, because that was something we were waiting on, was to make sure that the path of the line sets was adequate. And that was the only letter I saw. So we had a December 15th letter, but it only addressed these things. We didn't have, keep scrolling down. Did we have
The
I don't
letter
think we
that
had the letter
was
that
in
we
the
just saw.
I believe it's the same letter.
This is the letter that was included in the January 16th.
But this is a different letter. It's the same
Oh, I'm
date.
sorry. It is a different letter. Yes,
but
you're
it is
correct.
different. This one is strictly for the refrigerant lines. And basically this led me, I was led to believe that the rest of the application, because we were waiting on whatever LARCA to finalize things, that this essentially was the final piece to the puzzle, which in reality there was a whole nother letter that basically said your shaft's still not approved. We approved the exhaust on the roof and the condenser on the roof, but we don't approve the actual way to get to the exhaust, which obviously is a little bit of an issue, because you don't need an exhaust fan if you don't have a grease duct to go to it. So okay, so does anybody want to ask legal any questions? Because I sort of do.
Yes.
All right. I'm going to make a motion that we move to executive session.
Mike Beal, second.
All right. There's a motion in a second. All those in favor say aye.
Aye.
Right.
Aye.
Aye.
All right. Motion passes 6-0. Bear with us, everybody. We'll be back. We're going to go talk with our legal counsel, and then we'll be back. Tony, I was gonna make a cleansing motion, but my throat is hurting. Could you help me
Yeah,
out?
I heard you say that you move that the members of the DRB affirm to the best of their knowledge that only those matters appropriate for executive session involving consultation with counsel were heard or discussed during executive session.
Yep, that is exactly what I said. Do I hear an approval on that?
I would say a second as such, right?
All right. All those in favor of that, say aye.
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 All right, motion passes 6-0. All right, so based on our executive session, I'm gonna make a motion to defer the application to allow staff to investigate the documentation from the appellant and the approval and non-approval letter from LARCA.
I will second.
All right, there's a motion and a second. All those in favor, say aye.
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 Any against? Any abstentions? All right, motion passes 6-0. All right. Moving on to another appeal at 12196 Sanibel Court.
This is from the applicant, and the applicant is here, asking him to unmute. Nick, you are unmuted.
Hello, how you doing? Yeah, so I got my attorney. Her name is Tina Charvet. She will be speaking on my behalf. So if you don't mind unmuting her, please.
Sure, no problem. Tina, I just sent you a request to unmute. You are now unmuted.
Hi there. Thank you for having us. As Nick said, I'm Tina Charvet. I'm here on his behalf. So his fence was denied by letter dated January 30, and we believe that with the letter there was a misapplication of the guidelines, the design guidelines for Sanibel Cluster. Those guidelines permit fences that are of notched design, that are mahogany brown in color, and they're limited to 6 feet high. Mr. Arzani's fence exactly complies with those specifications, and that's even stated in the January 30 letter, that those specifications are set out as what his fence meets. So based on the published guidelines, the fence appears to be in full conformity with what is permitted and should have been approved. And in the letter, there's no statement of any deficiency of the fence. So we request that the denial would be reversed and that the fence would be approved.
Okay. Staff, can you show slide 10, please? So this is the cluster guideline. And so you're saying that we misapplied what portion of it here?
Well, maybe the entirety, because there was nothing specified in the letter that pointed out any deficiency. So the color of the fence is mahogany brown. It's notched construction and it's 6 feet high.
When you say notched construction, what are you referencing?
So if you look under fence design, it says notched fence board. Mr. Arzani did receive an email from Genesis Fonseca that confirmed that the notch design was appropriate for Sanibel Cluster, and she had pictures of it, which is exactly the way his was built.
Michael, she's referring to the dog ears on the fence post itself at the top.
Yeah.
Gotcha. Okay. All right. Now, just if you also look at this same guideline, if you look in, it clearly states that it needs to be a board-on-board fence, which means there's boards on both sides of the fence. And this applicant only has boards on one side of the fence. So if we could clarify our denial if that helps, but you know, the fence does not meet the guideline.
So the letter did not state that was the issue. The information that Ms. Fonseca provided shows the construction as built. You know, the boards joined side by side.
Yeah, I think our letter probably could have better said that it's not in conformance with the cluster standard for fencing, which is why it was disapproved. Because it's not a board-on-board fence. It has a board on one side. But let me see if anyone else has any questions for you. John, do you have any questions?
No.
Jim, do you have any questions?
I do not.
Mike, do you have any questions?
No, sir.
Brian, do you have any questions?
No.
Emily, do you have any questions?
No.
Staff, my only question for you. I know I was on this panel. Who else was on the panel with me? I think John was.
It was John and Brian on the panel with you.
Oh, Brian, okay. So myself, John, and Brian cannot vote on the appeal. So that leaves Jim, Mike, B, and Emily. I was on the thing. We're allowed to talk. To me, I think our denial letter could have been clearer. That says it doesn't meet, because the color is right, the fence height is right, the fence board is okay, but it doesn't have the board-on-board feature, which is clear for the cluster that says it needs to be a board-on-board style fence, and it has a top rail, which this is also missing. So it has a top rail and a board-on-board. It's pretty clear in the guideline that is required by the drawings, as well as the description there. So that is why we denied it, just as a, so.
So excuse me for interrupting, but the information provided to him by Ms. Fonseca is a photo of an approved fence, or the design approved, and it shows the construction exactly as done, with the boards abutting, each side, without any top rail, because the dog eared, as you call it, it doesn't really accommodate a top rail. So there's confusion about that. He's relied on that representation as having been approved for Sanibel, and understanding that is what notched fence board means.
Yeah, top rail or not, though, I think we can agree that the guideline is clear that it needs to be a board on board, which if you zoom up right there, on that little section there is showing the 1x6 boards on both sides of the fence. And then if you go to the applicant's fence picture, there's only boards on one side. I mean,
Right.
I don't mean to be curt, but it's just it's clear that they don't have boards on both sides. So he can keep the fence as is. He just needs to add boards on the other side, and then he's going to be in compliance with the board on board. I mean, there might be a little rework done with the existing board so he can get the proper kind of spacing. But if done properly, he might even be able to just take boards off the one side, move some over, and then create the board on board effect, which is what is in the drawing.
Okay, I think that might be workable for.
Yeah, it's not like he needs to take the whole thing down or anything. It's just he needs to install it per that drawing there. I think the notched dog ears, to me, I think you've proven that it is in the guideline that it says notched board is okay, and so to me that would be acceptable. But I do think the board on board is pretty clear in the guideline.
Okay, well, if you could revise the decision, then that would be, I believe, acceptable. I can't talk with Mr. Arzani right now. Maybe he can hear us. But the original letter said to remove it, but if we can amend it, amend the letter, and so we can alter the fence. That
Yeah,
would
and we can clarify. So staff, if we need to clarify our letter, do we need to? I mean, to me, if he brings the fence within the cluster guidelines, he doesn't even need an application. Is that correct, staff?
That is correct.
So theoretically, if he just brings it within compliance, then this would all go away. Or do we need to actually, do we need to amend our letter that says that he can modify the existing fence to conform with cluster standards within 90 days? And then that way, it basically, because this does say that he needs to remove the fence. It doesn't say that he can, just basically build the fence in the proper manner.
So you can't revise the decision unless you accept the appeal. And the staff can work with the applicant to provide additional time to ensure that the fence complies with the standard, or they can submit an alternative application in which staff could provide a approval if it conforms to the cluster standard. And that decision, I believe, would take precedent because it's a new application, and it would comply with the DRB's approved cluster standard for fences in Sanibel cluster.
Yeah, and so theoretically, if he just follows the cluster standard, though, he doesn't necessarily need to come back with a new application. It would just be, because is this part of a POA? Like, what brought this thing upon? Just a complaint or a POA or what?
LaShonda, do we?
Yes, so this application originated from, this was a,
I was trying to let me look at my agenda, you might say.
A complaint.
complaint.
The
It's originally a complaint from the cluster.
From the cluster. Yeah, so to me, our decision letter could have been clearer that said, to bring it in conformance with the cluster standard within 90 days, removed or brought within conform. Well, it does say that. It says along with the restoration of, oh no, that's saying restore the front elevation. So we don't really need to accept the appeal just to amend the letter, because to me, the fence as approved as submitted is not going to be approved.
We are happy to work with the property owner to provide additional time to correct. That is not a problem. We can actually send an additional follow-up letter. But unfortunately, because of the appeal requirements, the DRB can't make a decision tonight because 3 of you are required to abstain, and that only leaves 3 of you remaining.
If I could just interject, an additional letter would be helpful. One thing we want to avoid is having a letter in the file years down the road that says to remove the fence, and then have additional work be done, and not have something showing that he was operating within what he's permitted to do. We don't want him to sell the house and then have to be in trouble.
That makes sense.
Ms. Charvet, just so that you and the homeowner are aware, a part of our process is to come back after an application has been approved. So that property owner would receive notification of inconformance for their property file. For any future issues or concerns, they would have that letter that's tangible for them to deliver if it was an issue or concern. Once the fence is corrected, we do come back to the property to ensure that there's compliance with it.
And Cam, just correct me if I'm wrong, but you were saying that we can't, can we do any motion tonight? Or you're saying because there's 3 of us that have to abstain, we can't Tony is saying that legal is saying that we cannot make a vote on this tonight because let's say a hypothetical 3 yays and 3 abstentions cannot work. Is that accurate?
I believe that's correct, but Tony, correct me if I'm wrong. If there's an alternative motion that's not related to the appeal, but revising the decision, does that permit the DRB to make that decision? As long as, okay. So you can revise the decision with unanimous decision because you need 2/3 majority of
But the appeal would need to be granted first before we did that. No.
No.
We can
It
just
would be-
revise the letter with
Yeah,
unanimous.
you'd be revising the decision previously.
And can I make a motion as that, even though I was on the original panel?
Correct.
Yeah, it was your decision, right? You were part of that.
Yeah, so I'm allowed to amend it.
The board can amend the previous decision, yes.
Okay. I'm just clarifying to make sure I can personally make the motion. So I will make a motion to amend the decision letter for the previously disapproved fence to include that the applicant can amend the existing fence installation to come in compliance with the cluster standard guidelines within 90 days of the decision letter. So he can either remove it or amend it to come in compliance with the cluster standards.
I'll second.
All right, so the motion to amend in a second. Is there any further discussion on that? All right, all those in favor, say aye.
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 Any against? Any abstentions? All right, motion passes 6-0. All right,
Michael, I have a comment, and this is more for the cluster in general. Their drawing, their sample of what they have for their fence boards is showing what is sort of known as a shadow box fence, but they're calling it a board on board, which might be part of the confusion. So I think we defer to drawings over nomenclature, but that might be something to address and bring up to the cluster if they're updating their standards, because a board on board is a board touching a board, but they're showing a shadow box design. So I for what that's worth, I could understand how that's confusing. I don't think that changes in this instance because the drawing does show a shadow box style fence with a board on either side, but that's just a nugget.
I think staff, if you guys could just work with them and maybe, I don't know, it looks like these cluster standards are somewhat updated, but I don't know if it's in the new format. These look like they might be in the older format still. So I'm sure staff will work with them to get it updated, nomenclature and all.
Thank you, Emily. I brought that up before, but it is an issue.
Some of it's just colloquialisms. We all call stuff different things, but be consistent.
Tomato.
Yeah.
Potato.
Does anybody? I don't have anything else. Does anyone else have any other thoughts, comments?
I do not. Since we changed the decision letter, do we need to act on the appeal to close that order of business?
It's a good question. Tony? Cam, Tony, staff, anybody?
Well, you can't make a decision on the appeal at all because that part would.
And there you go.
Yeah.
Okay.
So from that standpoint, then, from a procedural point, do we, defer any further action on this pending a revision of the previous decision letter?
Well, maybe the attorney is still on the call. Do we unmute the homeowner and ask him if he will withdraw his appeal on this particular request? The new revised decision letter will be sent within 7 days. And of course, if the property owner is not satisfied with that decision, he can of course appeal that decision.
Do we need to
Nick, you're unmuted.
I'm sorry. Do we need to do anything to withdraw it by submitting anything or?
An email would be sufficient.
Okay, we'll do that.
Okay, great. All right, well then, does anyone have a motion to adjourn?
So move.
All right, do I hear a second?
I'll
Second.
All right, all those in favor, say aye.
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 Thank
All
you
right.
all.
Aye.
Have a good night.
All right, motion passes. We can adjourn. Thank you, guys. Thank you, Cam. Thank you, Tony. Thank you, LaShonda. Thank you, Trevor. Thank you, whoever on staff. I didn't. Thank you.
Thank you, Patrick. Thank you.
Good night, everybody.
Have a good
Thank you,
night.
Patrick. I didn't see Patrick. Is he on?
He's
Not
on.
here. Oh, here he is. Thank you, Patrick.
You're
See you.
welcome. I'm here.
Good night.
Good night, everyone. Thank you.
Night, guys.